Jai Hind everyone. On this beautiful morning, I, Afreen Almas, is pleased to welcome each and every one of you to a guest lecture on the occasion of International Literacy Day. This day is celebrated to remind the public of the importance of literacy as a matter of dignity and human rights, and to advance the literacy agenda towards a more literate and sustainable society. To ensure no one is left behind, we need to enrich and transform the existing learning spaces through an integrated approach and enable learning perspective of lifelong learning. What other day would have been better than this to touch the legal perspective and experiences by a renowned guest speaker. As a part of Subharti culture and also as a small initiative towards environment, we welcome our guest with the sapling of plant. So now I request our Dean Sir and our Honorable Vice Chancellor Sir to kindly welcome our guest, Shri Sajju Jacob Sir, with sapling. Our speaker for today's event is Adocate Sajju Jacob, a man who has been longly associated with famous late Advocate Lily Thomas. Now, if we look at the profile of Sir, Sir has done his BA and LLB from Government Law College, Ernakulam. Sir holds LLM in Comparative Constitutional Law from Bombay University. He holds another LLM degree from Cologne University in Private International Law. Sir has passed and cleared his solicitor exam and training at BPP University, London. Sir also holds an MBA degree from Mitchell College, South Alabama University, USA. Sir is affiliated to number of national and international bodies. He holds an affiliation with the Law Society, London. He is licensed to practice in German courts in Cologne. Sir is a bar council associated with Bar Council of Cologne, Germany. Sir is also associated with Supreme Bar Council Association. He is affiliated to Indo-German Chamber of Commerce and many more. Sir is also impaneled as advocate lawyer with the Bank of India, zonal office in Delhi and head office in Mumbai. Sir is a legal advisor to Indo-German Consultancy Services. He is also a legal advisor to Kornvisa Zentrum, Germany, and to many others. Sir holds additional qualification and training at the Peace Palace International Court of Justice, Hague, Netherlands. If we look at his working experience from the year 1998 to 2008, Sir has been senior associate in colleges in German Consultancy Services, Germany. From 1990 to 1998, Sir has been a junior advocate at the office of Advocate late Lily Thomas, and he has practiced in High Court of Kerala and District Court. Sir's litigation practices from 2008 to 2022 he has extensively worked on writ petitions, SLPs, appeals, and argued independently for independent institutional clients like Bank of India, specifically pertaining to RTI, Sarfazi Act, bankruptcy matters, contempt cases, and many more. Sir has represented arbitration matters on behalf of various international clients. Sir has also drafted international agreement for multinational companies hailing from Germany. So with that extensive profile of our guest for today, I would like to also tell you that he has published many articles and research papers in national and international publications. With that note, I would like to call our guest for today, Shri Jacob ji, to enrich our students.
Namaskar ji. Namaste. A wonderful good morning. Guten Morgen, that is in German language. Bonjour is in French language. And finally from Malayalam language, where I come from, Namaskaram. Vanakkam, Tamil language. Today is Onam festival in Kerala, and it is also a day of international literature. In my Kerala office as well as in Delhi office and also in European offices, we have possessed and we have acquired more than 2.5 lakh books in Indian laws as well as international laws in various languages, starting from Latin, Syrian, French, German, Hindi, Sanskrit, Tamil and Malayalam. As you know, our country is a beautiful country of a garden of various languages and cultures. And as such, we also possess and acquire various books from various cultures and nationalities. I wish you a very, very intellectual day for you from our interaction, and I hope you all are law students from various years. Am I right? You have started your first year and you are going to end up your final year as well. Is that correct? Postgraduate students are also there. Very good to hear that, because I have taught few years in Bombay as well as in Delhi and in Germany. Even now I teach for postgraduate students in their own language. In Germany I teach in German language. In Bombay I teach in English language as well as sometimes in Hindi and Marathi. Since I have done my first LLM from Bombay University, and wherever I go I study their language, and it is one of my weakness that I study and I fall in love with their language and culture. That is the way I have learned these languages. The language is the most important key to the world. So if you can speak various languages, you can attain the real moksha in your professional life. Till that point of time, you have to fight for your fairy tale. That is not easy job in our profession, as you know very well. And I lead my 33rd year. This is a tough year for me, because I have been doing every day various case laws in Supreme Court as well as in German courts. And my day start at about 5 o'clock and finish at about 12:30 night. And today when my friend has visited my office, my clerk has said to him, which he told me, that I didn't sleep for the last 1 week, which is a matter of truth. Every day you have a lot of things to do, and this is the way you have to work. And every day, if you have started your LLB classes, or if you have embarked upon a journey of legal profession, you should start your day at about 5 o'clock. The moment you get up early in the morning, you should do your yoga or whatever prayer that you do, and afterwards you should get into your library. You should start your day, professional day, at about 6. And at about 8:30 you can go for your breakfast. And this should be your tapasya, sannyasa. Otherwise you will never achieve and attain moksha in this profession. Having said all these things, I wish to enter into today's discussion, which is comparative study of common law and civil law. You know that in legal profession, you have two important cultures. Thank you very much. Who are the students of LLM? Yes, 1, 2, yes, 3. And you are doing in which subject? Criminal and constitutional law. Very good. And sir, you? Same. Very good. And LLB final year students? Very good. And who has actually motivated and inspired you to come here for this lecture? That, motivator should be congratulated. Who has motivated you to come here? Your own will or your professors? Very good. Because I have more than 40 colleagues in Delhi office as well as in Kerala office. I asked them whether your professors were really good. And they say that yes, they all are really good. So my first question will be then, can you just tell me the preamble of Indian Constitution? You can? Very good. You all can. I am proud of you. I am proud of you because I also belong to your profession. You also belong to our profession. And preamble is the first gateway to this legal profession because it finally gives you a door to our country's legal, political, social and economical world. Yes, directly entering to legal profession but also indirectly entering into the world of knowledge and wisdom. This profession is a noble profession, as you know very well. Great people have entered into this profession and they have fought for their own countries. Everyone who has, in the 20th century, you have great people like Martin Luther King and also Abraham Lincoln, John F. Kennedy, and in our country you have Gandhi, Nehru, Sardar Vallabhbhai Patel and great other lawyers. And they all have fought for our country, including Subhash Chandra Bose, though he was not a lawyer, I think. But all others who have contributed to their own country, they all were great lawyers. And in Europe as well, you know that various European revolutions have contributed to great deal of freedom. French Revolution, 30 years of German war, and even before that, the war in UK, which has led finally to Magna Carta of 12,015, which was signed by King John II. And all these. So let me ask you about Magna Carta. Who knows what is Magna Carta? The constitutional students? Of course, for being LLB students, it is not necessary to know about Magna Carta, but you should know basically the Indian Constitution. But for the LLM students, Magna Carta is the must subject. And Magna Carta, and without Magna Carta, you cannot pursue this profession as a lawyer. And finally, if you want to practice in High Court as well as in the Supreme Court, you should know what is Magna Carta. So who wants to practice law out of you? Among you, who wants to practice law? Somebody wants to pursue the profession as a corporate lawyer? That means desktop lawyer. They make agreements for the merger, for the acquisition, for the big agreements. That is desktop lawyers. Then lawyers like me, litigation, every day appearing in Supreme Court and High Court and international courts. We argue for our clients. They are multi-billionaires or very big institutional clients like Reserve Bank of India or Bank of India, Punjab National Bank or big LIC, this and that, or big BMW or Mercedes-Benz. So, what do you want to become? Can you tell me, ma'am? What do you want to become in your life? You are pursuing LLB first year. Huh? You have just joined. Who are, your colleagues in your first year LLB degree? Okay. You all want to become lawyer, or have you made up your mind? What is your vision and what is your mission?
I want to pursue judiciary.
Judiciary. Very good. Yes. And everyone wants to pursue judiciary. Now, who wants to pursue litigation or corporate law? Very good, very good. So judiciary is also very good. You are going to decide the future of millions of litigants. That is good. So for the judiciary students also, you should know the basic fundamental freedom and rights are given to Indian citizens. Before 1947, we were subjects of the British Kingdom. Now we are the citizens after 1947, and it was given by the Indian Constitution, isn't it? You can sit down. You can sit down. So let me give you some, I am sure that you all know, and first year LLB students know little bit, but second year and third year students know very much about the world, constitutions and various cultures. Maybe you will not understand everything, whatever I say today, because you are at the, beginning of your wisdom, the, horizon of wisdom. You would take little time to understand all these legal principles and theories. But there are two cultures, famous legal cultures. One is common law and one is civil law. Common law means India belongs to common law countries, and that is, the culture, legal culture followed by greater countries of United Kingdom. All the countries, Australia, US, Canada, South Africa, India, and all other countries like Malaysia, this and that, they all follow the common law. There are 82 countries, small and big, and they all follow the common law culture, because we are part of the common law. India, though independent and a republic, we are still part and parcel of common law countries. We have also a common law club or association. We are part of that. India is still part of that common law association. And then our capital, when it comes to legal issues, is actually right now the Supreme Court. And afterwards, what do we look up, or what we look upon? We look upon various decisions given by Privy Council in UK. Privy Council in UK has given various judgments, and we look upon those kinds of references, and we take the help and assistance from that judgments. Even while we argue the matters in Supreme Court, if we don't have the judgments from Indian Supreme Court, because our Supreme Court is very new, it is established only after 1950. So if we don't have such kind of Supreme Court judgments from Indian perspective, we look at the Privy Council judgments. In Delhi and in India, I think there are very few law officers which has still the books and judgments, the journals of Privy Council, and my law office, thanks to Lily Thomas, we still have the books, journals starting from 1859. We still have that books, and we still follow the Privy Council judgments. Yeah. If we don't have the judgments from Indian Supreme Court. Before that, we did have what? Various charter high courts. That was in Lahore, that was in Bombay, that was in Chennai, and that was in Calcutta. We didn't have Supreme Court. After the charter high courts, our appeal lies to Privy Council before 1947. And afterwards, it goes to House of Lords. So what is common law? Common law is actually the law used by the then English people in their country. So common means actually, the ordinary people. Common, that is what they mean. So their Lok Sabha is still called as House of Commons. They say and they mean that it is the house, legislative or parliamentary house of common people. That is what we call the law passed by the House of Common is the common law. And we have actually followed their culture, and that's why legal culture, and that's why we call it common law culture. So we belong to that common law. And the countries like India, South Africa, Australia, Canada, and US, and many other, Ireland, many other countries still, 82 countries still follow this common law culture. That means common law culture has some commonalities. Number one, and India has some exceptions that I will explain to you. And that is because of our forefathers and drafters of Indian Constitution. They have studied codified law, that is civil law. I will embark upon that discussion after a few minutes. Let me come back to the common law with its own with its commonalities. What is the commonality of the common law? Common law means basically, let us take the example of UK. Do we have constitution in UK? Does India have? And our constitution is written constitution. Our constitution is written constitution. And UK constitution is oral is not that correct, but it is not wrong. But unwritten constitution. UK constitution is unwritten constitution. That does mean that they don't have any written constitution. Is that so? Is that so? No. They have also written constitution. Not like ours, codified into one constitution. Constitution means what? Constitution of rights and duties given to citizens and its functionalities of various government or state organizations. Our Indian Constitution gives utmost respect, authority, power and liberty to Indian citizen through its chapter 3, starting from article, yes, and it goes up to 30, and the 32 is, yes, and article 19. So what are the most important 3 articles of Indian Constitution? Exactly. What do these 3 articles say and talk about? Golden triangle. What does it say? The liberty, freedom, the right given to the citizenry. And is that not written in UK Constitution? It is written. It is written in Magna Carta and in the year 1215 and signed by John the King II. And he has not given that power to us or to the people, not out of his will, but out of a long fight between the government as well as the people, as well as the citizenry. Till that point of time, even the UK people were subjects for the king. But in 1215, the UK people, they have led a revolution for 14 years, and afterwards the king was compelled to sign the Magna Carta. And that is the first written constitution, though it is not codified in like Indian Constitution. And the habeas corpus, the famous charter, is guaranteed in that Magna Carta. You know what is habeas corpus. Can anyone stand up and tell me what is habeas corpus?
Sir, habeas corpus is the writ that is issued by the Supreme Court of India when
Or High Court?
or the High Court under 226. It states that you have the body. It is issued when a person is illegally detained by the authorities and it is issued to flee them.
Exactly. And in one word, habeas corpus means?
You have the body. Pick the body.
Corpus means? Body. Habeas means? Exactly. That is because at that point of time, if somebody speaks against the power, killed, not more seen anywhere, thrown into some river, lakes or somewhere. So that was the first revolt made by the people against the power. And finally king was compelled to sign the Magna Carta. So that starts with the story of the constitution. But we still have the common law culture wherein we don't have many countries without constitution. Or if at all, many countries have only few articles in the constitution. Which is that country? The smallest constitution in the world is owned by whom? Which is the famous country in the common law world other than UK and India? United States. How many articles does it have? 7 or 5? The original constitution. It has afterwards amended, extended, but the original constitution is only 5 articles. The only 5 articles. A country like United States is being controlled with the 5 articles. Whereas Indian constitution, 395, exactly. And which are the other countries that do not have constitution, written constitution? UK we have discussed, US now we have discussed. Many African common law countries don't have written constitution. But instead, what do they have? We do have judgments by the highest court, Supreme Court or higher court. Because of the rule prevailing in our common law countries with respect to law of precedence. Precedent means judgments, case laws. If Supreme Court has decided a matter in a similar issue, of any other life incident, life has too many incidents in various aspects, divorce, criminal cases, civil matters, corporate matters. So in all these matters, Supreme Court takes its own decision, and we all are bound to follow because of the law of precedence. And we have too many theories related to that. Too many theories. But the civil law countries don't follow law of precedence. Apart from the constitution, apart from the statutes or statutory laws, common law countries have the precedents or case laws which stands and rest upon the transcendental place. It has its great place in our life, case laws, precedents. In comparison to common law, civil laws don't have the precedents, except in the constitutional matter. In the constitutional matter, civil law countries follow the precedents. But in all other life incidents, They don't need to follow civil laws. Judges look into and they study the case laws, but they are not bound to follow in civil law countries. That is the biggest difference between a civil law country as well as common law country. Let us take the example of Germany. Germany does have a constitution. Germany does have a constitution, written constitution. And that is also one of the important characteristics of civil law countries. The civil law country will have always codified law. Without codified law, civil law countries will not work. And the famous countries are Italy, Germany, France, Spain, Portugal, and all South American countries, because it was there, all the South American countries were actually the countries affiliated to Portugal and Spain. So they have completely around more than 96 countries totally for the civil law countries. And civil law countries including Thailand has taken recently the German law. Japan has taken German law. Because in civil law countries, each and every aspect of the life is very much codified. Say, for example, you have university lecture and you come late for a lecture. 15 minutes late arrival is allowed. That is called, according to them, the academic 15 minutes grace period. In 60 minutes, you can avoid 15 minutes, but 45 minutes you have to be there. Even that is a small part of a life. It's a small incident of a life. So everything and all these small incidents are correctly codified, written. And that's why they have less room for interpretation by the courts. They don't need to. Judges don't need to interpret because it is already codified. They only need to look at the code, the law. The most important characteristic of a codified law or civil law, that is the best way to understand. Civil law means codified laws. Common law means unwritten laws, not codified, but everything depends on the precedents. Whereas in civil law countries, everything is codified. Each and every incident of a life is codified by the parliament and state legislature. So judges don't need to. They can only follow the book. If you argue a matter in German court, and which I have done recently, you don't need to get into interpretation. You only need to get into the law books. So they would say a very famous saying in their language, you don't need to know what the law is. You only need to know where the law is. So you should basically understand where the law is, which law. Because they have hell lot of codified laws. And even there is civil law. One book has more than 2,500 sections. And in India, CPC, CRPC, IPC, and all these other statutory laws, it will not have 3,000 or 2,500 laws. So they have such kind of big books. And their commentaries are a big volume. So that volume starts from there, it goes up to that, and it was codified in the year 1900. It was codified by them in the year 1900. And it is primarily made by passed by the legislature or parliament and passed by the parliamentarians, but who makes it? Parliamentarians as such, they just pass it, they discuss it if it affects the constitutional matters. But all other matters are made by the professors or the lawyers. They will make a committee for that. And that's why they call their laws are professorial laws. So they will always form a committee of professors and lawyers, and they will allow them to make suggestions on that particular issue, and then they put forward that suggestion before the subject committee of the parliament or legislature, and they deliberate it. Generally, the parliamentarians or the state MLAs don't get into too much intricacies or small matters. They will generally pass all the suggestions given by the professors, and that is why it is called a professorial law. I hope you are following me.
Yes, sir.
Is it a boring for you?
No, sir.
Then I will give you an example for you to think. I can also make a joke. Then you will laugh. That is a good thing. But being student of the law, and I am also student of the law, and I am very happy to hear today morning a very famous sentence from your dean. When he introduced me, he said, I am the student of law. That is a great thing. We learn every day. That is why we are doing practice. We never work. We never do job. We do practice on a daily basis. And that's why every day we are the servants of Saraswati. We learn every day. We are the student till our death. The most important thing from Indian perspective that you need to know, that you don't pursue this profession for money making, instead for enhancing the wisdom. You should marry with the Saraswati, who represents the wisdom. Then what will happen to you? Finally, you don't need to necessarily marry the Lakshmi, because she will follow the elder sister, Saraswati. So you get both if you marry Saraswati. And that is why I have a great appreciation for your dean, who has introduced himself to me, saying that I am the student of law. It's a humbleness, it's a nobility, and I am so happy to see you all as a student of your guru who is sitting in front of me, and I am hopeful that all the professors and lecturers also follow his nobility and humbleness, which is the most important credential for our profession who pursue this tapasya, this sannyasya, life of sannyasa. So let us come back to that famous intellectual exercise which I was talking about, and we were talking about the civil law and codified law. Civil law has I have already talked about the common law and its origin, but civil law, that has its origin from Italy, Latin country, because in Italy they speak Latin at that point of time. I come originally from Kerala, where we used to, and my grandfather used to speak Sanskrit, Syrian language, and also Latin. And at our home, we used to sing all the Sanskrit chants, and also Gita and all the Hindu philosophy, as well as the Italian chants in Latin language, and also the Syrian. And in the later part of the century, we have started even learning Arabic language. So I was very lucky to hear all these language in literature form, or in its beautiful literature form, that is music and chants. So I have started hearing this Latin language even at my childhood days. And one of the most famous Latin chant what I heard, and that is originally from the civil code, that you all know, that you shall not be your own judge. And what is written in language and what is we follow? Even the common law country and civil law country follow this theory. What is that? Nemo. Nemo. You stand up. One of you stand up and say. I will help you. I will give you clues. Yeah. Exactly. Great, my dear. What is your name? Well, you should be a judge in the future. Because that is the important statement for a judge. You know that. Nemo? Okay. Can you just spell it exactly? Nemo. Explain. Spell out and explain.
No one can be judged in its own case.
And Nemo means?
No one.
Suva means?
Case.
No.
Self.
And then? Judex? Judge or law. Nemo, suvo, then? Causa means? Its own cause. That means cause of action or case. You shall not be judge of your own case. Every incident in our life, we are actually the followers of our own previous generation. It doesn't mean that, and I am not saying that you have previously born to someone else, that is not, or you have previously born somewhere else, that is not. But we are following such kind of principles from the past generation. When the King Caesar was alive, and that was actually at the time when the Rome was having its clout and power up to Israel, and it was before 2005 years ago, and Caesar was the king of Rome. And what has happened in his life? And you just look at the beauty of that theory and how does that particular theory comes into our life and how does it play a role. The King Caesar was the ruler of the then imperium, starting from Rome to Israel. And his father died and he was about to be throned and declared as a king. Till that point of time, he was only a prince. And his famous girlfriend, and even at that point of time, girlfriend is equivalent to the wife. His famous girlfriend has organized a gala dance party for his boyfriend to become the king. On the night, during the gala event, his clerk wanted to see the beautiful fronts of the prince girlfriends. So you all are laughing now, no? It is true, it happened. And this clerk, Antonio, has attired in woman dress, clowned himself and entered into this gala party as a woman. Then he started dancing with the girlfriends of, this prince girlfriend. So he was enjoying the night as a, young boy of 22 years old, and somehow his dress fell down and his real face appeared, and he was caught by police at red hand. And the king Caesar or Caesario was there. He has seen everything what has happened. That meeting ended. That clerk, he was 22, 23 years old boy. He was arrested. He was detained in the police custody. The next day, they were about to take him to the trial court for a trial. At about 10 o'clock early in the morning, the Lord Cicero became king, and then he has terminated his wife or divorced his wife. And the reason being that Nemo, no one should be the judge of his own case. And what did he say? She is my wife and I am the witness. And tomorrow, and my police is the prosecution. So I am the investigation agency, I am the prosecutor. And today it will be tried before the trial court, and tomorrow it will be tried before me as an appellate judge, because I am going to hear his appeal if he is convicted. So what he has done, he has divorced his wife and said sorry to him, saying that I cannot hear his case if I marry you. And I am, as a lord, as a king, compelled to hear his case. But if I am going to hear his case, what I can do? I shall not be your husband, so I divorce you. Isn't it a great philosophy? Isn't it a great philosophy? Can you remember such kind of incidents in our country or in other countries' world? Very rarely you see that. Very rarely. So this is not about saying something good about Cicero. I don't agree with him in many other matters. But when it comes to legal stuff, he has always set good principles, as good as our king also, but common law countries also. So this is what India has pursued. Common law countries has its own virtues and values, and they display that values in their system. I practice in both jurisdictions. I think there is no other lawyer who practices in both jurisdictions, civil law as well as common law. I practice in India, I practice in UK, I practice in Ireland. Not I go directly everywhere. My officers or my juniors or my colleagues go and do this litigation on a daily basis, and they are also desktop lawyers. They sit every day, write agreements on mergers and acquisitions. But as a litigation lawyer, I go to these countries, including Germany, where you have completely different set of laws. You practice law differently. You know why? Even in the practice also you see that difference. The civil law countries, court will start exactly at 9:30 or 10 o'clock. And court will give appointment to the lawyers. If you have a case, in a civil country, you will get the date at least 2 months or 3 months in advance, and appointment exactly at 11 o'clock, 10:30, and you can reach the court and you will be received with a bouquet or coffee or tea by the judge. He will be waiting for you. And if he is 2 minutes late or 3 minutes late, he will come alone, and he will come and say sorry, even to the litigants, even to the accused, even to the prisoner, everyone. And whether he is a Supreme Court judge or High Court judge, that doesn't matter. And then he will open his chamber, courtroom. He will go and take and collect all the court and everything from the litigants. keep it in the shelf. Then he will go to his podium. Then he will say good morning, this and that. And he will ask, you need coffee, tea, this and that. How are you? Is there any other issue? Everything is okay. Weather is good. Raining is, were you late today, or do you have any other problem? Do you want me to adjourn the matter? Once he decides to conduct the case, he will switch on his recording. Then he starts proceeding, and then he becomes a judge. Till that point of time, he is an ordinary human being. And after the case is over, he is become again an ordinary human being. And then he goes along with you out of the court, and he closes the room. And this is the practice that you have in all the civil law countries. But in common law countries, system is different. Judges are respected in such a way that their entire life is protected. Because we have a system of law of precedence. They have to read law. They have to spend their whole lifetime for the building up of their wisdom. So they cannot waste their time. So our life, whether we are accused guilty or innocent, or we are litigant, or we are plaintiff, we are respondent, that doesn't matter. Our life is decided by the judges. Whereas in codified law countries, life is almost decided by the statutes. And it is easy for the lawyers to say, if a client comes to the lawyer and asks whether I have got a good case and whether I will be winning this case, then lawyer can say, you have got a very good case, it's a winnable case. Whereas in our country, what do we say? There is a chance, it's a good case. We cannot say more than that, because it is like between the devil and sea. You can win, you can also lose. You cannot say, because it is all up to the interpretation of law through the words of lawyers and application of law by using your skills, linguistic skills, as well as your intellectual capacity or intellectual exercise. And judge has to exercise his own jurisdiction. In the civil court jurisdiction, you as a judge don't have much room for the widest interpretation, whereas we in common law countries, we have got a greater room for interpretation, and judges have greater place. And that's why you can see even in the ordinary life of a judge, that kind of difference. In the civil law countries, judges are respected only for that particular moment. Having said all those things, I should also say one important thing, that in the codified law countries, constitution and its decisions are binding. I think you have gotten the basic idea of two cultures, common law as well as civil law. You understand what I say? And the basic, there are also a lot of differences between common law as well as civil law countries. When it comes to practice, this is, really going to make a big difference. Say, for example, if you look at the death costs day first day in Bombay, Cyrus Mystery has sacrificed his life for the negligence he has caused. Isn't it, sir? It's a negligence. And we are also party to such kind of negligence, we society. And we are also, yesterday I was talking about this situation to some other group, and we never follow the rules. We never follow the principles. We never follow anything, whatever is written in the manuals or guidelines. Because in the car manuals, in the safety manuals, in the security manuals, everywhere it is written, and there is a belt also on the rear seat, on the back seat. Still we don't follow that. We just keep it. We just keep it as an ornamental piece, and we behave like a king at the back side. And the front seat driver is a driver. Even if he or she is our brother or wife, we behave as if we were the kings and we never wear the belt. And Mistry is a great man of our country. He's a great industrialist, entrepreneur. And in other words, he is also an anthropologist. But he has given up his life to his own negligence. And the reason is that we always try to bypass the law. You start a company, and what do you do at first? You go to a chartered accountant after the 1 year and try to save your tax by doing this and that. And that is the duty what chartered accountant believes, that it is his sacred duty that he has to bypass all the laws and get you the best benefit or the most benefits. In Europe or in codified countries, what do? They will say very clearly, this is the law, this is the rule, you have to obey it, otherwise you don't need to come to me, because I am becoming party to the offense and I am colluding with you. And that is the problem. If you start hijacking the laws and bypassing the law. That is the problem with these common law countries as well as civil law countries. Civil law countries are the countries that follow strictly the law. If you go to Europe and see anyone crossing the red light, they are either Malaysians, Indonesians, or Indians, or South Asians, or East Europeans. They don't do that. And they will look at us. Who is this guy crossing the road? And easily you can understand, either we have a turban, or we have a pajama, or we have, some kind of traditional signals on our body to sign that we are from Malaysia or Indonesia. And if they are Europeans, they will not do. Codified law countries. But common law countries, Americans are also not following the law exactly. So you should not feel bad about that. If you go to Canada, you don't see that much violations, but you still find a lot of Canadians violating the rules. Because we have that basic difference in the interpretation of law. Even in the criminal law, let me take you, my dear friends, you have the adversarial system in the criminal law, which I respect because I am a criminal lawyer. I do constitutional law, I do criminal law in Supreme Court, High Court, as well as in the trial court when there is a 302 and 376. That is what I do. So in 302 or 376 or with, in serious crimes, what we do in the trial court? Adversarial system. Those who follow the criminal jurisprudence, we know that we follow the adversarial system. Whereas the civil law countries follow investigative or inquisitorial criminal jurisprudence. What is the difference? Anyone knows? Anyone knows? We are very much privileged to have adversarial system, and thanks to our drafters, constitutional makers, and the great lawyers of our country, we have followed that system. Because I am not a follower of civil law countries when it comes to criminal jurisprudence. Inquisitorial system doesn't offer any kind of defense to the accused. Say for example, I am right now pursuing a 302 matter and trial is going on, and my advantage is in India, and I do the same in Europe, and I have a different principles to follow. In India, my advantage is, or in Ireland, that I can compete with the prosecution and I can challenge him though I don't need to challenge in India. I only need to say, no, I didn't do. I didn't do. Prosecution, investigation can say, you have killed me. You have killed my brother. I only need to say, I didn't. You have to prove it. It's your duty. You prove it. And I only need to challenge it. I only need to challenge their evidence. Because I am equally competent to stand along with the prosecution. I am the defense lawyer. I am the accused. And I can compete with them. Equally negotiate before the court of law. Judge cannot stop you. And district court judges or magistrate courts, if they know the law, and mostly they follow the ethics. Unless and until you become, unless and until you become directly a magistrate. You should not become directly a magistrate. You should practice at least 2-3 years. You should know the heartburns of this profession. Then you understand the real side of the story. The real story of the other side. That you should understand. Because in life, people say many things you don't believe. The moment you become lawyer, what you say? I know. Not anymore, I think, I presume, I assume. These are not the lawyer's words. A good lawyer will always speak the words of wisdom, and he will speak, I know. I know the code, I know the section. And exactly if you know the law, you can win a case, especially in criminal matters. Whereas if you go to civil law countries and you do the murder case, what is going to happen? The investigative or inquisitorial jurisdiction. They follow the inquisitorial jurisdiction. What do the judge do? The prosecution has no job to do over there. Prosecution has given all their documents, primary statement, evidence, and all those things. And it is for the court to decide. And court will ask the questions directly to the accused. Tell him to produce all the evidence if you want to negate it. And it is very difficult. You can prove something which is positive. You cannot prove negative because it is not there. You cannot even, you can prove only one negative thing, alibi. You can say that I was not there at that particular point of time and I was away. Either you have to produce a flight ticket or, in one of my case, I have produced. My client was in India and the opposite party has claimed that he has signed the agreement, which is wrong. It is completely a wrong story. So I have proved. Likewise, you have to prove the negative stuff. And the judge will enter into inquisitive mode. He will start asking questions to the accused and also the defense lawyer. Because it is his duty to find out the truth and it is his job. And they are into the finding jurisdiction of the truth. Whereas the common law countries they are into the common law countries enter into the finding mission of evidences. We look for the evidence from the prosecution. And if we challenge the prosecution and if we are able to showcase various probabilities and create the mind of doubt in the mind of judge, he cannot punish as per common law. You understand? The moment you have a confusion, doubt in your mind whether he has done it. Say for example, that I am telling you from my lifetime experience which is right now going on in a 302 matter. The case is, I will not enter into the merits of the case because it is not correct. The case is, that a man is jumped out of auto rickshaw. While the auto rickshaw was in a motion of running condition of 40 to 60 kilometer, the auto rickshaw is in motion, and he has jumped out of auto rickshaw. And what has happened? He died. And due to the back end injuries, inside injuries of the head. I am trying to give you the lifetime example in simple words so that you understand. And also it creates some kind of interest in you. It's a job of a lawyer. Police has registered the case, immediately arrested the driver, saying that he has killed him, along with his another driver sitting in the auto rickshaw. That driver was sitting along with that person in the auto rickshaw on the back seat. So police has immediately taken him into custody, and he is in jail. Personal liberty is affected. That man's family's livelihood is deprived because he doesn't have a job anymore. Wife, kids, they don't have money. He is sitting in jail for the last 2.5 years. Trial is going on. And that man who is deceased, if he was alive, he would have told the story what has happened. So it is your duty now to find out the truth, whether the police is right or my client is right. And I talk to my client, he say, I haven't done. We were trying to help, but he was in a mood of committing suicide, and he has jumped out of the auto rickshaw, and he has had the habit of committing suicide, and there is a history of his psycho analysis. That analysis says that he was a patient of committing suicide, and he dreams even at night how he can jump out of his life because of the poverty, because of the troubles that he faced. So he dreams. That is the story. And we have found out all these stories from his friends. You understand what I say? So according to my client, he has not done any offense. Instead, he has committed suicide. He has jumped out of the auto rickshaw. So what is the option available to you? And his friends, the friends of deceased, know that he has the habit of committing suicide. He is suffering from that kind of psycho problems. And even his wife also said that he even dreams that. Some people are like that. Some people suffer from such kind of psychopath life, So what is my job? I have IO, investigation officer. I have medical experts. I have eyewitness. But in this case, both eyewitnesses are in jail. And I have only the IO as well as the medical expert. Medical expert postmortem story and the autopsy report say that this man has died because of back injury, inside injury. So how can I prove that? How can I? There is no eyewitness. If there is eyewitness, we could at least ask him. So there is only circumstantial evidence. IO will always try to prove his case because he is the one who was investigated and he wants his case to be successful. So he will never make any compromise. So what is my job? I have 3 important people, 2 doctors, and they can say whether this guy has jumped out of auto rickshaw or they have pushed him out, and that is the only option I have. So the skill of a lawyer. If you jump out of a auto rickshaw, you are using your own will You have taken a decision. I have to run off the situation. I have to run out of the life. I have to commit suicide. That is what you want. So you use your own will. And you use your feet for that. And again, the platform, the auto rickshaw platform. You jump out of the auto rickshaw on your own will with the support of two hands. And that jumping is different than the pushing by an external third party. So how can you distinguish that? You have to use the physics. You have to use the velocity of the body when it jumps out of, a body jumps out of the running auto rickshaw at a speed of 40 to 60 kilometers. And what would be the body's reaction when it fall down on the earth, which is static? Which is static. Auto rickshaw is running. Your body is also in the mode of running. So earth or ground is in static position. What will happen if you jump out of your own will using the platform and the velocity and the power? What is the power of the body at that particular point? It is not your power. It is horsepower. It is exactly like you have that psycho problem. You want to attain your seal. You know, some people who suffer from epilepsy, you can save all the people who suffer from epilepsy if they do anything, but if they jump into a well, you cannot save. The people who jump into well, you just leave him. It is better that he dies. Otherwise, what will happen? He will take you as well into the deep of the water, into the deep of the sea. That is the life experience. Epileptic people, if they jump into well or water, they will not come back. They will take you because their power is doubled. They have horsepower to take you along with into the deep of the sea or into the deep of the well, and they will also kill you. They are not killing you, but it is not their intention, but it happens. Exactly, if you have decided to commit suicide and jump out of your own will from the platform of the auto rickshaw with your own hand, and you jump with a objective, and your forehead will hit on the static earth, whereas your body is still on the motion because you are running and jumping out of the running auto rickshaw. So your upper body will not be in the motion, whereas your legs will be still in the motion. And your mind is also still in the motion. What will happen? And if I, third party, push a person from the auto rickshaw, and if I fall down because of the third party's pressure, and I am sitting in the auto rickshaw, not in the shape of committing suicide, so then no, I am just sitting as a normal person, and I may be fighting with my colleague, fellow passenger, and still the force of that fall will be different than the force of a suicide. And that is my duty to prove. And I should use physics for that. I should use velocity. I should use the speed of the auto rickshaw. That is what you can also see in Cyrus Mystery's case. If he has used belt, his forehead will not fall on the top of the front seater. His body will be blocked by the belt, because belt is the first security, and then you have the airbag. So you will be blocked by your belt, and your head will hit on airbag. But if you don't use belt, your head will jump on the top of the front seater, and then you will hit back, and then you will die on the injuries suffering in your inside brain and at the back. So there are different type of falling. One you fall on the forehead, one you fall on the back end, and the injuries sustain afterwards. And this beauty of a lawyer, the skill of lawyer, can be very much portrayed and displayed in Indian adversarial system. Whereas in inquisitorial system, Judge will decide all these things. In our country or in common law countries, judges are only the monitors. They can only watch the proceedings. They cannot do more than that. And if I tell, say for example, 2 weeks back I have done a trial. When the postmortem doctor started explaining his own theories, we said no, we don't need. My junior colleague said, you have no job to do. You say yes or no, we ask probabilities and it is our job. And then they sought immediately the interference of judge. He said, I cannot. It is his job. It is his duty. It is his right. He has probabilities. He knows his subject. If he uses various theories with respect to biology, chemistry, philosophy, metaphysics, we use all the theories. That is our knowledge, our wisdom. And we are lawyers in that respect. In civil law countries, you don't have this. The judge will ask and he will find out the truth. And he can reach to any conclusion. Whereas here, I can question the wisdom of the judge and he cannot. We have the power. The lawyers have the power. So in common law countries, since many things are and can be interpreted by the judges, the lawyers have great role to play. And it is a good thing. You feel like, you are a great lawyer if you do your job. And that is the difference. So you all are going to become a great lawyer and you should become great lawyer in your own belt. In the future, you are going to become great leaders of the country, either in constitutional law or criminal law or in various legal field relating to the incidents of our life. Every person is supposed to face lot of or myriads of turbulences in life. Nobody is free from troubles. No lunch is free. So you have to work hard. For that you have to invest your energy and time in you so that there will be a competition. In that competition you will be having enemies. So you will definitely meet with your problems in the life. That is quite normal and you should embrace each and every problem as an opportunity and use your knowledge as a lawyer. The legal acumen that you all possess in the years ahead, that is going to help you and you should make it as an opportunity. You should become great lawyers, great judges, great destiny makers of this country and let our country lead to what did Tagore said? The brightness of wisdom, and let our country come out of the darkness if it suffers from. And as written in Gitanjali, let our head be held high. What? You should read that. He has written a great poem. We, the people and stakeholders of this country, should keep our head high and hold high because we respect and embrace the values and we marry the Saraswati for that, not the Lakshmi. Lakshmi will automatically follow, being the younger sister of the Saraswati. With this sentence, I conclude my speech and I am so happy that you, all my junior young colleagues, have eagerly given and attended my lecture and with all the patience you have heard me. Thank you very much. And I tell you a small example. When I wanted to do my PhD, I have gone to UK for doing my PhD after my first LLM. And I am lucky to have been taught by Dr. Chandrajud, who is the current sitting judge of the Supreme Court. He has taught me comparative constitutional law, and he has taught me the difference between common law and civil law 30 years back in 1991 and 1992. And he is the one who has taught me and given me the enlightenment of civil law countries, and also talked about the common law countries. I was also an honorary like a lawyer like you. I didn't know anything, because he has come from Harvard after having done his PhD, and he has taught me all these things. And I am a great fan of him, even at that point of time. He has never looked at his books. He has given his wisdom beyond the books, and that is the beauty. He has always done his lectures in a extempore mood. And afterwards, when I went to UK for doing PhD, I was invited by a German professor to do PhD in Germany. And I immediately accepted his offer, and I moved to Germany. And I have studied German law again, and I became a German law, and after having learned German language as well. So one day I hope, and that was a risky move, because nobody would move to another country with a different legal culture and language. But I did it, and I am happy that I did make a turn in my life by marrying a different culture as my profession. Now I am come back because of my mother, Lily Thomas, and I am sure you all might have studied Lily Thomas case laws, or if you haven't studied case laws or constitution, you will slowly study the constitution. And Lily Thomas, without Lily Thomas, you cannot pass law. And when you think about Lily Thomas or study the Lily Thomas, you just think about me and this photo. Our life is committed to Indian Constitution, and we sacrifice ourselves for the development of constitutional laws. Thank you very much.